right for any person, whether EFCC chairman or any person for that matter, to tar all lawyers with the bribe of being involved in money laundering. And we issued a statement, and we challenged the EFCC chairman to come up with empirical evidence, and that if he cannot, never to make such statements. And unfortunately, he's one of us, a lawyer. We issued a statement, and we drew his attention to the fact that many men and women who make the investigation and prosecution of the case by EFCC worthwhile are lawyers. Is he also suggested that those lawyers are aiding money laundering and financing of terrorism? It is common in Nigeria for people to make hasty generalization, and yet very few lawyers, to my knowledge, have been prosecuted by the EFCC for aiding money laundering. We are proud members of the legal profession, and we draw a line in performing our professional duties and in aiding the commission of crime. We don't do that. There may be a few bad eggs, but that does not represent the picture or the majority of lawyers who toil to build up a reputation of integrity, a reputation of professionalism, and an EFCC chairman should not, for whatever reason, soil that image by portraying all of us, me and you, as aiders of money laundering.
All right, welcome back. Well, yes, he's right here with us, Afam Osigwe, the president of Nigerian Bar Association. Good morning, and thank you for coming on today.
Thank you for having me.
First time we're hosting you as president. Congratulations to you having emerged. So we know that it's something that has been in the works for a while, you know, lots of background work. But incidentally, your vision in your manifesto, you were speaking about you wanted to run an inclusive bar that identifies problems, anticipates challenges, and delivers solutions and benefits to all lawyers. It looks as if we identify one problem right there with that particular scenario. But before we come to that, so having emerged and you've been going about with your several responsibilities, how are you coming through with all of them so far?
Well, Rome, as they say, was not built in a day. And I indicated in my campaign, in the course of the campaign, that some of the problems we identified or challenges will not be solved in a problem. They're part of institution building. And because a number of them will require collaboration with the heads of court, with the National Judicial Council, and working with the State Judicial Services Committee. So it's just about identifying them and prioritizing them as things that need to be done. I mean, one of such things is about our courts deploying technology to ensure that the hearing of cases in our courts go on smoothly, that the filing of cases, service of processes. And so, in these days of insecurity, high cost of traveling and all that, and I believe that if we deploy technology, you don't need to travel from Lagos to come to Abuja to file process at the Court of Appeal or Supreme Court or Federal High Court, or you need any court for that matter. That if the legal mail project, which the NJC has been driving for some years, comes on stream and all courts key into it, you can, from the comfort of your office or home even, file a process in a court in any part of Nigeria. Mm-hmm. And if a bailiff needs to serve you a hearing notice, they will serve you. And if a court would not sit, you would be notified. And a number of things would be easy and seamless. And it would also be very easy to retrieve processes filed or to access them from any location in the world, because they will be available online, saved in the cloud, and so you can't through any device access them. And I believe that this is the way to go in this age and time. And a judge can have virtual hearings and do so many things without people really having to travel all the times. I mean, imagine traveling from Maiduguri to the Supreme Court just to hear for a motion for enlargement of time for the filing of a process to be done. And I believe the Supreme Court can take this virtually. There's a whole lot of things we can do. And we talked about also ensuring that processes filed in court are in an electronically retrievable manner. So if you go to some of our courts, they have a problem of space. You see files sometimes piled up in corridors, and sometimes some of these documents are destroyed. And these are some of the things we talk about. They make life easier. And it will be easy also for the courts when they deliver judgments, for these judgments to be available real time on the portals of these courts. So sometimes groundbreaking judgments are delivered in the UK, for example, or in America. And we have those documents immediately. So they are partnered with private companies that are able to, a public government body that certifies the judgment immediately they are delivered and they are really available. And we can do this. The Corporate Affairs Commission has also shown that public documents can be available on the site of a government agency. So upon payment of if you want to get an extract of a company now, you go to the Corporate Affairs Commission portal, and then you put the relevant details and pay the fees, and it will be emailed to you. And we think our courts can work this way. You don't need to wait for a whole week or weeks for you to get judgment delivered by a court. And it has given rise to situations where sometimes people will argue that there are different versions of a certified true copy of a judgment, or people will speculate about what the court decided because they are waiting for the judgment delivered by the court, and they are relying on what journalists say. And sometimes some of these journalists are not in agreement as to what the court really decided. Or we don't have the benefit of the reasoning behind the conclusion, the court's the reasoning behind the court's conclusions. And so sometimes too, this leads to so many speculations, misinterpretation and misrepresentation of court judgments, and they have in no small measure helped in doing damage to the judiciary, because people say different things and draw their own conclusions and sometimes impute ill motive to the court.
These are very interesting changes and reforms when they do come on stream, because, I mean, for instance now, you know, just like I think we have with security, even with media, the judiciary, if a judge delivers a particular judgment, maybe a political one, and people feel, no, it should not have gone this way, then we'll begin to, of course, judiciary will be bashed. So all kinds of narratives will come through, rightly or wrongly. And then sometimes too, as you highlighted, people could travel to a particular location for a judgment or even for a hearing or a proceeding in the court. And the prosecution can call the judge and say, I'm sorry, I can't be available today, despite people have traveled and done all of that. And then they are adjourned.
Happen.
And that happens lately.
You spent money, you've traveled, you've gone, you're waiting in the court, and somebody comes and says, oh, well, we are sorry, my lord will not be sitting today. Yeah. Or if it's an appellate court, you say, oh, we are sorry, the court could not form a quorum. If in the previous day this information is available, even days, you will be notified. You receive an email, you receive a phone call.
So at this changes
the National Industrial Court have pioneered it. Some individual judges are doing it.
So it's not,
but
it's not supposed to be.
It should be an institutional thing. It should be a way of doing things. I mean, in some cases, you may not be able to guard against it. For example, a judge sat yesterday, was prepared to continue sitting the next day, and suddenly takes ill on the morning. That can be, it's understandable. But where it happens all the time, and there's no systemic way of ensuring that there's proper public communication as to whether the court will see it or what would happen, so it can be very annoying and very destructive.
What's your targets now to achieve these objectives?
Now, like I said, I'm talking about the NBA engaging with the heads of courts and the NJC.
Okay.
We can't do this alone. The Chief Justice of Nigeria, as the chairman of the National Judiciary Council, has a lot of role to play in this. The bar will engage with them. And for example, we're doing some engagement at the moment with respect to liberty of citizens. So there are provisions in the Police Act, the Administration of Criminal Justice Act that require that chief magistrates visit detention facilities, and judges of the State High Court and Federal High Court visit detention facilities like the one by the SSS or DSS, as we like to call them now, and NDL, or the law enforcement agencies, to look at their detention facilities, to find out how long people have been held there, to grant bail to some persons, or give an order that the person be charged to court. That is observed more in the breach. So there's real force to cooperate with the chief judges, for example, to give directive and follow through to ensure that the magistrates, where these holding facilities or detention facilities are located, perform these statutory duties of visiting them and carrying out their functions. So this requires multi-sectoral collaboration for them to work.
I want to be able to talk about the reputation of lawyers, because that is this event happened in Abuja, by the way, where the EFCC boss actually said, and I want to be able to quote him, It was at the annual Criminal Law Review Conference right here in Abuja. So let's hear him. I want to be able to quote him word for word. The most traumatic discovery of the EFCC in recent years was that the subjugation of national interest and well-being to personnel interest by lawyers who aided briefcase foreign investors to fleece the nation in dubious transactions. The PNID scam, the Mambila Power Project, and some rights issues are cases in point. And he goes on to say that no mega financial fraud can be perfected without the input of lawyers. I heard you responding to that, saying if he has proof, he should, meet you in court, to have that. But I want to be able to talk about the reputation of lawyers, because he said this, and as much as you may take issue with some of the things that he said, the actual reputation of lawyers is being brought into question. It's a conversation that has been going on for quite a while. How are these crimes that we see in court, all these people that we see having to face justice at some point, how were they able to perpetrate these crimes without the input of lawyers? Is that something, apart from how you feel about how he said, is that something that the NBA thinks about?
So, I'll be the first to admit that some of our colleagues do not always do the right thing. But I would not agree to a situation where the impression is given that lawyers generate crimes. Just the same way I would not say because buildings collapse and kill people, all engineers are very bad people. Or because a few doctors perform abortion procedures unlawfully, that all doctors are murderers. That would be wrong. My response to the EFCC chairman is to the extent that such statements should be made with some level of circumspection so as to avoid creating the impression that every one of us out there is a criminal. He is one of us, and we're very proud of the work he's doing as chairman of the EFCC. And it would be wrong for me to suggest that because he's doing that work, and maybe a few EFCC operatives or officers are doing what the law says they should not do, that he too acts in an untoward manner, or that he's a criminal, or he encourages corruption or commission of crime. That would be very wrong. The point we are making is that such statements should be made in context so as not to tear every lawyer and portray them as criminals. I know we are doing a lot of work with him and the NFIU on issues of tackling money laundering and involvement of lawyers in them, financing of terrorism. And all of us are doing that also to ensure that Nigeria is removed from the grey list of the Financial Action Task Force. So, and I had a conversation with him after saying, well, he was taken out of context, and we've left it at that. We have no personal fight with him, but we're only asking for caution, because many people internationally will rate Nigerian lawyers based on what such higher-ranking public officials say, and we're only saying it will not be good. And that the boast of the EFCC about the achievements in fighting corruption and financial crimes, or financial crimes and economic crimes, can largely be attributable to the work being done by the lawyers who have gone to court to prosecute these offenses of alleged offenders, and who have advised the operatives who investigate as to what to look for to meet the legal elements required to secure prosecution or to build up a watertight case. Would it also, if such a generalization is allowed, would it also not suggest that they too may in their own little way also be encouraging that? So what I think the important message to get is that while we may admit that there may be some bad eggs within every profession, that in trying to identify the role they play to encouraging such criminal activities to happen, that care must be taken so as not to portray every person as being like them. Of course, people, even in tax practitioners, invite people to advise them on how to look at the law and find ways legally permissible as to avoid some tax obligations. It may not necessarily mean that they've committed a crime, but they have just found some loophole in the law. States may not like the fact that people are utilizing loopholes in laws not to pay as much tax as they should be. But in some cases, these are legitimate and lawful. The point we are making, yes, there may be lawyers who have been involved. There may be lawyers who have crossed the line in providing legal services. And the NBA will not protect such lawyers or speak up for them where they are found wanting. That is why there's also room for lawyers who have abused the practice of their profession by joining in the commission of the crime, in which case they no longer act in their capacity as lawyers, but have become active participants in the commission of the crime, they can be prosecuted. And if there are such persons, prosecute them, shows evidence.
Does that not raise questions about the legal and disciplining lawyers? That committee, because there are questions as to, is that really as efficient, and do the public see it as efficient as the lawyers think it is?
Well, I actually don't also think that our disciplinary process is efficient. I think it's one of the issues also we intend to tackle. At the moment, the process of disciplining lawyers is rather slow, and that is attributable to the state of the law. We have what they call the Legal Practitioners Disciplinary Committee, which only sits in Abuja. So which means that if a lawyer practicing in my hometown in Anambra State is accused of having committed a professional misconduct, and the complainant is also there in Nnewi, they would all have to come and is brought before the LPDC, as the acronym for it. He has to spend money to travel from Nnewi to Abuja. Likewise, the lawyers responded for that matter to be heard. And because of the number of cases they have to hear, they can't finish this matter, so they may have to adjourn, and it is slow. And then the lawyer, if he's found culpable, has a right of appeal to the Supreme Court. And we think that there is need to decentralize the hearing of these disciplinary processes such that the committee can sit either in the states or in the regions. And it's also to look at ways of making this process move fast so that disciplinary matters can be dealt with. Because if we don't show an ability to discipline our errant members, the public will not have confidence in us. If we don't show a willingness and an ability to weed out those who give a bad name to the profession, who put their professional position to the wrong use, to call them to order and punish them. People who trust us as legal practitioners and come to us, confide in us, give us their services and pay for our services, and who in process suffer on account of our abusing our privileged position, will not have confidence, will not trust lawyers. So that disciplinary process must be seen to work. And I will agree with you that it's not working as efficiently and as effectively as it should be expected to work.
Do you think that change will happen before your tenure is up?
Where conversations are on, the body of benchers is already on it, and everybody agrees. It is the Office of the Attorney General in trying to pioneer, to aggregate views on what should be put in a draft legal practitioners amendment bill presented to Federal Executive Council for approval to be presented to National Assembly as an executive bill. Is one of the priorities, one of the things being prioritized. And if we get to that stage and that draft document becomes a bill and National Assembly passes it, it is my hope or belief that it would help to speed up the process.
If I was Chamberlain's lawyer, I don't want to use you, but if I was his lawyer and he needed to circumvent something, didn't want to pay taxes, he's going to punch me after this show. So if he wanted to commit a crime and I'm his lawyer, and he came and met me and said, look, how do I get this done? And then I tell him, these are the loopholes. This is how you do it, sir. You know, and I do all of that, and he does it and gets away with it. Have I committed a crime as a lawyer?
Sure you have. If a client has evinced an intention to commit a crime and comes to you and you give him advice that aids him, you cancel him, you become a party to a crime. Because under the law, any person who cancels, aids, participates in the commission of a crime is a party to an offense. It doesn't matter that you didn't join in committing it. But if the client has committed a crime and is being investigated and he confides in you, you haven't committed a crime by hearing that. It's not your duty to go and tell the law enforcement agencies. Point I'm making here is that it is not the duty of a lawyer to tell a client on what he should do so as to make the commission of a crime seemingly safe so that he can be caught.
But that's different from...
So we are not to aid the commission of a crime.
But if he commits the crime and tells me...
In fact, you have a duty if a client has confided in you about the possibility, the plan to commit a crime. Some people will strongly argue that you have a duty to report that because it's no longer a privileged conversation.
But if it's a crime, it's clearly spelled out. But if it's a lawyer advising a client about the lacunas of the law, that's
no, if it's about lacunas in the law, so well, if you do this, you won't have committed an offense. But if you do this, it will be an offense because actually that's what we're supposed to do. If you don't do this, you will be guilty of an offense, or it's an infraction, you may open up yourself to a criminal investigation or to liabilities or penalties. So you give advisory services. But if the client says, look, I want to go and kill this person, tell me how I can kill him
and get away
with it. That's no longer your duty. If you give such advice, knowing the person intends to put it to use, you're no longer acting as a lawyer. You're acting as a party to a plan to murder another person.
But you must have heard about when the public keeps saying, I mean, the lawyers have talked about judicial reforms for life forever, you know, and then the public also wants to see improved judiciary such that all of this complaints about judge or lawyers doing this and that becomes history. So in terms of judicial reforms, do you think that at the end of the day, some of those reforms perhaps may address a lot of the perception, the wrong perception the public has about judges and delivering justice, at least in the first instance?
So I'll say this to you. It's not a one-way traffic. You can have all the reforms you want, copy the best system that has worked elsewhere, and the perception will still not go away if the perception is negative. It's also about those who administer its process and its system, how they do it, how do people perceive their decisions as being just. You can have a process that says, oh, all trials can end within 1 week, and the trials end in 5 days. So while you have achieved the speed that people expect from you, if people don't feel satisfied that the decisions you render are founded in law and fact, the fact that you have reformed with respect to time, speed, will not improve the negative image you suffer from. So it's about giving even-handed justice, as we say it in the legal profession, about appointing the right caliber of persons to be judicial officers, and about their reasoning being consistent. So part of the perception is that sometimes judgments of courts are contradictory and inconsistent, and that even lawyers complain that sometimes we are not able to advise our clients with certainty. So when you talk about perception, there's a whole gamut of things that need to be done beside the reforms, because you can get the best law that has worked elsewhere, elevated a country maybe from a third world to a first world, and have a first-class perception about the ability to do things, and then you don't get other aspects of it right. Then you have a problem.
I'm sorry, what do you mean that if you can advise clients? Because we see this a lot with political cases. You know, but it could be a state, it could be whatever it is, and then they go to court, this court gives this judgment, they go to a court of coordinate jurisdiction, gives a counter judgment. Sometimes here INEC says, look, we're confused, which one do we, okay, now which one came first?
So your question just made my point. Also, if on an issue, and I mean, if on an issue, for example, that the Court of Appeal is the last court of it, and I can get a judgment from, let's say, a division that says it is white. Another division says, oh, it is blue. Another division says, oh, it's actually a rainbow. Another one says, it's actually none of these. It's actually the clouds. And it happens more in political cases. And it has impacted much more negatively on the perception of the judiciary. And I hope I will live to see that day when our courts are less involved in political matters, especially issues relating to choice of candidates. And I hope I'll live to see that day maybe soon, where the issue of who is the party's candidate is not justiciable, so that the parties go sort themselves out. On such a day that the party's process of selecting candidates will be very, very transparent, such that people will be able to live with whoever, or the party can decide, you know what, yes, you may appear to be more popular, but we don't think this most popular candidate represents our ideals and views as to who should represent us or stand for election. This person that may not appear to be the most popular is our candidate, and the court should not question them. It should be an internal affairs of the party, more like going back to the pre-1979 situation, where the courts refrain from being sucked into them, because it is the political cases and the desperation of politicians to win at all costs. And also we have a role to play in it. We lawyers, ordinarily my teaching as a first-year law student, second-year law student, you're supposed to put before the court cases that are favorable to you and draw the court's attention to the ones that are not favorable to you. So sometimes these judges are human beings, sometimes in a rush, sometimes they may not advert their mind toward the decisions in the case, and sometimes one division may not know that another division has given a judgment on that matter.
But I thought that should be history.
Well, you may think it's that common and very easy. Yes, it should be, but it is what it is at the moment. But what we crave for the certainty and how we're going to achieve it, I do not know. I cannot tell you sitting down here at the moment. But we lawyers and litigants and the public wants to know that some certainty that if this is an issue, the court will likely decide it this way. Or even if we have no clear idea as to how we expect the court to decide it, but that when the court decides it, we should be able to read it and say, oh yes, we trust the court because this reasoning is sound and we don't think anything untoward happened in the delivery of judgment. Because when judgments start becoming look bizarre, when people go away scratching their head, oh, did the court really say this? That's when you have a problem. Or when you say, but the court, they said that in the other court the other day, and they said that, oh, I'm told there's a Supreme Court decision that said this. How come this lower, the Court of Appeal, decided something different from what the Supreme Court has said? This is why we have a problem. And I'm sure the Chief Justice of Nigeria in maiden address at the legal year hinted at some of this. But there's things we all need to do because we as lawyers don't want people looking at us as criminals or being parties to subordinate justice or being people that cannot trust that whatever you tell us to say, we'll keep saying. In civil crimes, if a lawyer argues a position that is inconsistent with earlier decisions of courts, it could be an issue of professional misconduct. But I'm not aware in Nigeria that we strongly think so. But we should, because a lawyer should not deliberately argue a position that does not represent the law or mislead the court into accepting as the correct position of the law, a position that is inconsistent with decided authorities.
If you're looking at
because the decisions of the court will be trusted if they are consistent and people can say, look, sure, this is what it's going to be because the court has said so. In England, there's still cycles of over 100 years ago and 200 years ago. And if for any reason the courts have to depart from it, there have to be a reasoned discourse. But part of the problem we have this also is that sometimes these courts depart from earlier decisions without expressly overruling the earlier one or saying why they are not following this one, even when they have been cited to them. They just give a new decision. And now we have that interesting theory in Nigeria that, well, if there are two inconsistent decisions by the same court, you take the most recent court one.
Yes.
It doesn't matter whether the most recent one was not as well decided and reasoned as the earlier one. But you say, well, since this one is later in time, you follow it.
Yeah, speaking of the code of conduct for the behavior of lawyers, one recent trend that we've started seeing is lawyers on social media. You know, speaking up very, very vehemently about cases that they're handling, getting into squabbles even on social media. Is there, I don't know if it's wrong or if it's right, but maybe you can educate us. Are there codes of conduct for how lawyers present themselves on social media?
Well, I didn't want to let the cat out of the bag, but we are working on developing a social media policy for lawyers and maybe getting the body we call the General Council of the Bar to look at it and possible consideration for inclusion in our rules of professional conduct. But it is unethical for any lawyer, whether you're directly involved in a case or not, to discuss a case that is ongoing in court, what we call sub judice. Lawyers are not supposed to comment on matters in a way that may likely affect the administration of justice. And it is worse when senior lawyers, including senior advocates, in their full robes, finish a hearing, come out of the court and they are granted an interview. And we intend to, going forward, take steps against any senior lawyer, or any lawyer for that matter, who grants an interview with any respect to a case pending in court. I will personally sign a petition against such a lawyer. And then that's
going to affect us, Chamberlain.
I said this to you.
We sort of wait until they come out.
I said this to you, except in some countries, maybe America, where people can speak about ongoing cases. In the UK, where we borrowed our legal system from, you can't go to ask a lawyer questions about what transpired in court. That is why you're a journalist or in court. You report on what you have seen, and you're not supposed to start running commentaries on them. When a judgment is rendered, you can discuss the judgment.
Okay.
But you can't be discussing the risk and giving an opinion as to what could have been or what didn't happen.
Yeah, so
that's totally wrong.
That will not affect us because we have creative ways of doing.
Well, we don't have any. We are not regulating you, but we are going to talking about lawyers who are involved in cases and who go on to discuss them.
Yeah, we understand
this is our profession. It makes us look no different from some other professions that are not as noble as ours.
Speaking about senior lawyers, you know, I mean, I know you must have also read in the time where judges based senior lawyers and say, how can you, all sorts of things.
I mean, you waste the time of the court.
Coming before
why would
the
you
court,
bring this frivolous matter?
Matters that you know as a baby junior lawyer that this should not be the case. How did you? So those things, we read them and public they're stunned as to what's going on here. And there's only one suspicion. Well, if they've been given a lot of money to go back and for that case. In fact, some even argue saying, listen, I want to go back to the Supreme Court to reinterpret their judgments. Those kind of things happen.
It's not to my knowledge that courts interpret their judgments. If a judgment is delivered, you don't need to go for interpretation. But my point is this, sir. And I made that in a meeting that took place under the auspices of the Chief Justice of Nigeria sometime last week. And I said, our courts should go further. Where a lawyer has brought, to refer a lawyer to this right committee, where a lawyer knows, for example, that the last court to entertain an appeal in a matter, for example, is the Court of Appeal, and you file that appeal in the Supreme Court. The court should go beyond imposing costs to be paid personally by the lawyer to refer that lawyer to disciplinary action, or exercise the disciplinary powers of the Supreme Court to discipline the person. People get away with so many things in Nigeria because actions don't have consequences. If an issue of law is so settled that there's nothing further can be said from the facts can only lead to one conclusion, and the lawyer still appeals on that issue, either because he needs a case to be a senior advocate of Nigeria, or because he has been so much paid that he shuts his eyes to decades-long or years-long authorities on that matter, and he has nothing new to urge the court. If we don't take actions, the too many appeals we have in our court will not stop, and our lawyers will not continue to, as Justice Moise said in a case, continue to, they will never cease to test the consistency of the courts. Because courts must be taken to be consistent. And if they have consistently held a position, and there's nothing new to be urged, a counsel should be able to do well to advise his or her client that, look, based on this authority, I'm sorry, we can't go on appeal. And maybe, too, the provision for obtaining leave to appeal in our court should be strongly implemented, so that you have to convince a court that there's an arguable issue for you to be allowed to appeal against that issue, for example, to the Supreme Court. But because most appeals, courts don't want that time wasted to hear argue application for leave and still have to, every appeal so that they want some for determining that. But we need to put stringent conditions to ensure that only cases that deserve it go. And I think I should use this opportunity to also say it. Many of the appeals in the Supreme Court are simply there because the process of appointing senior advocate is a quantitative process, not a qualitative process.
Oh, I see.
Why the rule says that the case you use must have contributed to.
You getting.
It must have continued, someone must have done something novel.
Oh, see.
The verification assessment process does not actually go into finding out whether that your case has done anything. And it doesn't even matter whether in that case you were thoroughly lambasted for wasting the time of the court. You just said, I have one judgment, I have a second one, I have three, my cases are complete. Nobody cares to ask, what have you added to the body of knowledge? Of what use was this appeal? What has this appeal achieved in substance? Other than maybe wasting of time of the court.
Okay, I know we'll be winding down, but let me just ask you this. There was a recent scenario that played out for the Ondo governorship elections. I think was it a day before or 2 days before the time, between the Labour Party's case. So eventually there was a judgment that came from court, I think a day or two before the elections, that I can't remember what's the name of the other candidates.
But who was the rightful candidate of the Labour Party?
Yeah. So in that particular matter, so is it that the courts are usually, don't they avert themselves to, this election is coming up on a particular date, and there are several processes and things that politicians need to do to prepare for those elections. So why deliver judgment a day or two before elections? Because politicians can use that as a leverage to knock off and weaken that political party and make sure that whoever wants to win disables their opponent. What's going to be done?
No, I agree with you that sometimes politicians can cleverly try to put a party on its wrong feet by contesting who was the candidate. And sometimes even a political party can also try to use it to get votes in support of two different candidates. But my point is that the judicialization of a party electoral process as to who represents a political party should be given a second look. We should consider whether it is still necessary for that matter to be justiciable. It has brought a bad name on our court. It has put a lot of work on our court. And I think it's time we did away with that. With time, we'll give political parties the autonomy to choose their candidates. Whoever they choose, whether people are accepted and like that or not, should be allowed to run.
But it has to be
while one may argue that it may bring about political, a lack of internal democracy in political parties. But my counter argument would be that it also give people an opportunity. If this party is not democratic, they may go to the one that is democratic. But our court should not be burdened with the issue of determining for political parties who should be the candidate they should put forward in an election.
What if we then say, look, if that matter has to be the case anyway, there has to be a time limit for it to be decided.
If it was not within time limit, the Court of Appeal would not have given that judgment a few days to the election. So I don't know the facts and the timeline, and that will be remit for me to be commenting on it. Yeah, and that takes me still back to the extent that it affects the choice of the people as to who they vote for in an election. The court should not be involved.
No, but
I don't want to conjecture or go into the facts of the particular by going into the facts of the election, but to the extent that who a political party is fielding could be subject of judicial adjudicatory process and occupy the court up to the eve of the election should not be encouraged.
So what, should they go to a tribunal?
The court should be insulated from it. Whoever the party presents their name forward should be their candidate.
When you say court, does it include tribunals?
Well, court or other tribunal. So, if you like they taught me administratively, where the court or other tribunal was used in the Constitution, who said that the court is a type of tribunal. It doesn't matter what name you call it. My point is, it should not be subject of judicial review. No court should determine for a political party.
But that can lead to impunity within political parties.
Then the voters have a right to say, because you, political party, you're full of impunity, we reject you.
But maybe that should have been said out at a particular time before the election.
In 1979, political parties chose their candidates. And I didn't hear so much cry about impunity. Let them choose. That's why they're political parties.
It's a different country now.
See, like I gave the example, you may be most popular, but a political party may feel that even though you're the most popular, you do not stand for what they believe they stand for. They mustn't field you. Let it be their internal decision. And if they keep abusing it, things will evolve over time. And the parties that respect the will of the people may get more support, may get more politicians going there. But the courts have been put in a very bad light because of their involvement in determining candidates for political parties.
If you could pick a time when these kinds of adjudication should be done before the
Constitution has the Constitution has done that.
Yeah. So when is it supposed to be? Because the Constitution says someone can come up 2 days to the election and do this and start the process.
I say this again. I do not know the full facts of the matter, and I wouldn't want to be sucked into it. But the Constitution has said, for example, elections should have 150 days, and that's why I put some timelines. For example, saying before the trial court is 180 days to determine it. At the appeal, 60 days from the date of judgment at the Court of Appeal, likewise Supreme Court. Why would the issue of the choice of a political matter go all the way to the Supreme Court? A Supreme Court of a country should be a policy court, should be a court that interprets the Constitution and brings about certainty where there are conflicting decisions of lower courts, like the Court of Appeal. Should not be a court that will be determining facts like who is candidate of a party. And that is why our court is overworked and overburdened, and the appeals keep coming in, and the politicians keep amending the Constitution to ensure that only their matters are determined within time. The commercial disputes, resolution of commercial disputes, which will give confidence to investors, especially foreign ones, to invest in Nigeria and believe that our judicial system will resolve any of their commercial disputes, are not working, and many businesses are being taken to foreign courts. It is not uncommon to see Nigerians sign an agreement and say that any dispute between them will be resolved by the Court of England or by an arbitral tribunal in London, Paris, or some other place. Imagine how much we are losing. Imagine how much we are suggesting that our judicial system cannot be trusted to resolve disputes, that only the foreign ones can give you credible results. Think about that.
Yeah, so now food for thoughts. We'll get your thoughts on that one. Unfortunately, we can't go to the point where we can ask, look, do you see a future in this country where judiciary can sack a president who perhaps the laws didn't agree with them?
I do.
In this country?
If it is within their powers to do so, I do. I see someday judiciary being able to do that. thinking they will not do that will mean that I believe that the judiciary is politically induced to give decisions to preserve whoever is in power, and I don't think so.
All right, Mr. Osigwe is the president of Nigerian Bar Association, also senior advocate of Nigeria. Thank you for coming on today.
Thank you for inviting me.
All right, Business Morning comes up now.